maeneo tofauti ya Commonwealth na hata bara la Afrika wamekuja kuangalia jinsi mahakama ya upeo itaendesha shughuli yake. Kumbuka kwamba baada ya David Maraga kuongoza baraza la majaji kutupilia mbali uchaguzi, ilisemwa kama it was a ruling that was precedent setting. It was something not seen in Africa basically. So tunajua kuwa leo pia kuna wale ambao wamefika kuona jinsi Martha Koome ataendesha kazi, na tunajua kuwa wakati walimaliza kusikiza kesi wakisema kuwa wanaenda hiyo likizo ndogo kuandika ile uamuzi wao, Martha Koome alisema kuwa wao kama majaji wanataka kufanya kazi kwa ushirikiano, wanataka kufanya kazi kwa pamoja. Tunasubiri kuona ikiwa kutakuwa na wao umoja katika maamuzi atakayotolewa, na ikiwa kutakuwa na baadhi ya majaji ambao labda watajitenga na masuala tofauti, tukijua kuwa kila mtu ana msimamo wake tofauti. Zuya?
Nilikuwa nataka kuongeza tu kidogo, ni kwamba kuna jambo jipi ambayo mahakama upeo imekumbatia siku hizi. Unapata kwamba wakitoa uamuzi wao lazima watoe kama kurasa 2 kando na ule uamuzi wa kamili kuelezea kwamba tumeamua hivi, hii inaashiria hivi, hii inamaanisha hivi. Kisha pale mwisho kuna jambo la cost ambayo hatujali
gharama ya kesi.
Naam, manake ikiwa kuweza kuwasilisha kesi kama hii ni lazima uwe na shilingi milioni 1.5, na kufanya hivyo ni ili tu kuonyesha mahakama, je, uko na uzito gani ama how serious are you in wanting to prosecute this matter. So ni lazima utoe ile pesa. Kisha baada hii yote tuliona zile ama karatasi volumes of papers that were brought before the court. Kwa hivyo ni swala ambalo tutaweza kuangalia baada ya kesi hii. Je, gharama yule ambaye atakuwa ameshindwa atambua ni pesa ngapi? Maana mawakili ambao wako hapa si kidogo, na wakili ambao wamejibeba wana uzito.
Lakini kuna uwezekano pia, kwa sababu hii ni kesi ambayo ni public interest case, inashughulikia masuala ya utaifa na taifa. President imetuonyesha hapo awali kesi kama ile ya BBI, kesi ya uchaguzi wa urais mwaka 2017. Kila aliyewasilisha kesi, kila aliyetetewa katika kesi hii aliambiwa sasa wewe shughulikia gharama yako. Na vile vile pia ni kujaribu pia kuimprove ama kuimarisha ile demokrasia yetu, utekelezaji wa katiba na masuala ya utaratibu wa uchaguzi. Na kama anavyosema Chemutai, ukiangalia swala nzima la chaguzi zetu, ukilinganisha na mataifa mengine, ukweli ni kwamba taifa la Kenya limepiga hatua sana katika taratibu za uchaguzi na vile vile taratibu za kikatiba na kitaasisi institutions. Kuna mataifa mengi sana ambayo labda wanashangaa Kenya kunaendaje. Ezin umefanya uchaguzi, siku zimepita 21 sasa, ukihesabu zile 7 za kuwasilisha kesi na hizi 14 za kusikiliza kesi. Siku 21 na taifa linaendelea, watu wanafanya biashara zao, mambo yanasonga. Sidhani swala hili lingefanyika miaka ya hapo awali. Ni kumaanisha ile spirit, ile roho ya katiba ambayo iliidhinishwa mwaka 2010 ina uhai wake unaonekana, utekelezaji wake unaonekana, kwamba kuna uchaguzi na baada ya uchaguzi kuna zile taasisi ambazo zimewekwa pale ambazo zinaweza kutumika na kutarajiwa kutumika kutatua kesi ama migogoro yote ambayo inaweza kuibuka.
Turejelee mahakamani za majaji ambao wamefika pale, tuweze kujua mbivu na mbichi.
Good afternoon and welcome to the Supreme Court of Kenya for the delivery of judgment in Presidential Election Petition number E005 of 2022 as consolidated with E001, E002, E003, E004, E007 and E008 of 2022, Raila Amolo Odinga and 6 others versus William Ruto and 13 others. The Honorable Chief Justice and the President of the Supreme Court is presiding.
Thank you. Very good afternoon, ladies and gentlemen. Yes, this is the judgment of the court, which is delivered pursuant through 23(1) of the Supreme Court Presidential Election Petition Rules 2017 in the presidential election held on the 9th August 2022. This is an abridged version of the judgment. The full judgment will be delivered after 21 days. Kenya is a sovereign multi-party democratic state whose foundations are firmly spelled in the Constitution. The Kenyan people's quest for electoral reforms since independence is well documented. That notwithstanding, and even without going back to the pre-1992 era, every cycle of elections has been highly contested, with the exception of 2002. This speaks to a background of distrust of the administration of our electoral process. Informed by this setting, Kenyans made a decision to vest the Supreme Court with the jurisdiction to determine questions regarding the validity of a presidential election under Article 140 of the Constitution. The reactions following the declaration of results of the presidential election of 9th August 2022 shows that the Independent Electoral and Boundaries Commission, IEBC, has not yet garnered universal public confidence and trust in the internal management of the Commission and elections. On the 15th August 2022, 6 days after the general elections were held, Mr. Wafula Chebukati, the chairperson of IEBC, announced the following results. Raila Odinga, 6.942, 930 votes, representing 48.85%. William Ruto, 7.176, 141 votes, representing 50.49%. David Wahiga, 31,987, representing 0.23%. George Wajakoya, 61,969, representing 0.44%. Based on the aforesaid results, the chairperson of IEBC declared William Samoei Ruto the first respondent, the presidential candidate for the United Democratic Alliance Party, as the president-elect. This declaration has precipitated a total of 9 presidential petitions that are filed before us, to wit, number 1, presidential election number 001 of 2022, John Njoroge Kamau versus Wafula Chebukati and 3 others, and Raila Amolo Odinga and 7 others named as interested parties. The second petition is presidential election number 002 of 2022, Youth Advocacy Africa and another versus IEBC and 12 others. Third petition, presidential election petition number 003 of 2022, Kerif Khalifa and 3 others versus IEBC and 3 others. Fourth petition, presidential election petition number 4 of 2022, David Kariuki Ngari versus IEBC and 9 others. 5, presidential election petition number 5 of 2022, Raila Amolo Odinga and another versus IEBC. 6, presidential election petition number 6 of 2022 by Moses Kuria and others versus Honorable Raila Amolo Odinga and 4 others named as interested parties. Number 7, Presidential election number 007 of 2022, Okia, Omtata, Okoiti and others versus IMBC and others. Number 8, petition number 008 of 2022, Julia Nyokabi Chege and others versus IMBC and 3 others. And the last one but not least, petition number 009 of 2022, Ruben Kigame Richete versus IMBC and others. In addition to these petitions, we received a total of 24 interlocutory applications and 1 preliminary objection, which were filed in this court. 2 of the presidential election petitions were struck out. That is petition number 006 and 009 of 2022 for failure to meet the constitutional threshold as set out under Article 140 of the Constitution. On 29 August 2022, this court also admitted 3 amici curiae briefs by the Law Society of Kenya, the Kenya section of International Commission of Jurists, and John Warubengo and 2 others. Upon perusing and considering the issues raised in the remaining presidential election petition numbers 001, 002, 003, 004, 005, 007, and 8, the responses and the submissions filed thereto, this court found that all the 7 petitions substantially raised similar issues and sought similar reliefs. Consequently, on 30th August 2022, this court ordered that the 7 petitions be consolidated and designated Presidential Election Petition number 005 of 2022 as the read file. From the consolidated petition, the responses filed and submissions filed by all the parties, the court crystallized the following issues for determination. And those issues are there. We have repeated them several times. I will not read them. Having considered and deliberated upon the consolidated petition, the attendant responses, submissions, and also considering the amici curiae briefs, we now make the following determination on issue number 1, which is whether the technology deployed by IMBC for the conduct of the 2022 general elections met the standards of integrity, verifiability, security, and transparency to guarantee accurate and verifiable results. As noted in the introduction, lack of trust in the electoral system has endured in Kenya for a long time. This led to the introduction of electoral technology following recommendations made by the Independent Review Commission on the general elections held on the 27th December 2007, popularly known as the Kriegler Commission report. That report recommended integration of technology into Kenya's electoral process for registration, identification of voters, and transmission of results. These were enacted in Section 44 of the Elections Act 2011. By this statute, IMBC is enjoined to adopt technology in the electoral process. As a consequence, the IMBC developed a technology known as Kenya Integrated Electoral Management System, KIMS, making Kenya's election process an hybrid as it employed both technology and manual processes. The first, third, and fourth petitioners in the consolidated petition challenge the technology used by IEBC during the 2022 general election. They plead that the manner in which technology was deployed and utilized fell short of the prescribed constitutional and statutory standards. As regards the audit of the register of voters, they urge that IEBC, pursuant to its elections operations plan, committed itself to conducting an audit of the register of voters by 31st March 2022. To the contrary, they arrange it only publicly availed the audit report on its website on 2nd August 2022, which was only 7 days to the elections. In this report, it was noted that the auditors established serious gaps and risk to the electoral process, including numerous cases of change of voter stations without knowledge or approval of the affected voters. Grant of voter update privileges in IEBC, IDMs, to 14 user accounts and related to voter registration. Reducing the accountability of user activities in the register of voters. Presence of 11 active generic accounts on the MBIS application and the 2 MBIS users with the same logging identification. Risking unauthorized system users, possible interference, change of particulars on the activation of voters in the system. IEBC's failure to set up access, decertification, and user activity review process. And IEBC was also arranged to have failed to respond to requests by auditors for crucial information. On the integrity of the technology deployed, it was the case for the seventh petitioner that in order to comply with Article 86 of the Constitution and Section 44 of the Elections Act, the technology deployed must be simple, accurate, verifiable, secure, accountable, and transparent. On the simplicity of technology, the seventh petitioner contends that the KIMS kits failed the tests as they were not easily usable by ordinary citizens without expert knowledge. They further assert that IEBC was expected to procure and put in place a technology necessary for the conduct of the general election at least 120 days before the election and ensure consultation with the relevant agencies, institutions, and stakeholders. Furthermore, the petitioners arranged that IEBC violated its constitutional duty by delegating the design, implementation, and conduct of the KIMS components of the election to a foreign company, Smartmatic International Holdings, BV. As a result, IEBC staff and the public did not have full comprehension of the KIMS components. They conclude, therefore, that IEBC abdicated and surrendered its role to conduct elections to Smartmatic, and that IEBC vigorously fought any attempt to subject Smartmatic's activities to accountability and transparency, including the safeguards required by Regulations 61, 69, and 75 of the Elections General Regulations 2012. In response, IEBC has submitted that the electoral system met the constitutional threshold, that all the necessary information was accessed only by the authorized persons. The information was accurate, complete, and protected from malicious modification, either by authorized or unauthorized persons. IEBC maintained an audit trail on activities related to information, and that the information was available and could be authenticated through the use of various security features. In further response, IEBC contended that they engaged KPMG on 7th April 2022 to conduct an audit of the register of voters, which was submitted on 18th June 2022. In addition, it issued a briefing on the report on 20th June 2022, summarizing the thematic areas therein and disclosing its findings as well as actions taken to remedy the issues identified. It also conducted its annual audit in compliance with Regulations 11 and 12 of the Election Technology Regulations 2017 and a certification of compliance issued to it on 3rd August 2022. IEBC relied on sworn affidavits by Michael Ouma, Moses Sunkuri, and Majan Hussein Majan on 26th August 2022, which were to the effect that it published the interim report by KPMG on 8th June 2022 and embarked on remedial measures aimed at effecting the recommendations ahead of publication of the final report. It was ascertained that it could not publish the full final audit report, as doing so would compromise the integrity and security of the electoral technology system, considering the provisions of the Data Protection Act, which imposes a duty to protect the data of Kenyan voters. On the other hand, the first and second respondents urged that even if there was failure of technology, it did not vitiate the result of the presidential election. Upon considering all the printing submissions and the ICT scrutiny and inspection tallying and recount report, which fully examined the IEBC's result transmission system, RTS, we are not persuaded by the allegation that the technology deployed by IEBC failed the standard of Article 86A of the Constitution on integrity, verifiability, security, and transparency for the following reasons. 1, whereas it is true that the KIMS kit failed in 235 polling stations, 86,889 voters were granted the right to vote manually, and the requisite forms 32A were duly filed. This happened successfully in Kibwezi West constituency and parts of Kakamega County. 2, while the audit report was released to the public 7 days before the 9th August election, the register of voters was used at the election without any apparent anomalies. 3, Smartmatic was procured to provide the necessary technological infrastructure, as IEBC did not have the capacity to do so. No credible evidence meeting the requisite standard of proof of access to the system by unauthorized persons was adduced by the petitioners. The scrutiny report prepared by the registrar of this court did not reveal any security breaches of the IEBC's RTS. IEBC successfully deployed a biometric voter register system which captures unique features of a voter's facial image, fingerprints, and civil data to register and update voter details across the country and also in the diaspora. The BVR captures a voter's facial image, fingerprints, and civil data, which features are unique to each of the voter. In compliance with Section 6A of the Elections Act 2011, IEBC opened the register of voters for verification of biometric data by members of the public for a period of 30 days. Thereafter, the register was revised to address issues arising from the verification exercise. KPMG then audited the register, and we are satisfied that the inconsistencies and inaccuracies identified during the audit were somewhat successfully addressed. The second issue was whether there was interference with the uploading and transmission of Forms 34A from the polling station to the IEBC public portal. The first petitioner arranged staging that a person who had access to the RTS intercepted, detained, or stored Forms 34A temporarily to convert or manipulate it before uploading it on IEBC's public portal. It is arranged also on 11th August 2022, IEBC dumped over 11,000 Forms 34A on the public portal between 11 to 11:09 hours. To rebut this allegation, IEBC and its chairperson, in their response dated 26th August 2022, denied staging and unauthorized intrusion of the RTS. In that regard, they urged that every image of Form 34A was uploaded immediately after the transmittal of results. The form was received as evidence by the timestamp. Similarly, the first respondent denied these allegations. Our finding: 1, no credible evidence was presented to prove that anyone accessed the RTS to intercept, detain, or store Forms 34A temporarily before they were uploaded to the public portal. The allegation that 11,000 Forms 34A were affected by staging was similarly not proved. 2, the allegation that IEBC, its officials and strangers used a tool to tamper with the Forms 34A before converting them to the portable document format, that is PDF, that eventually appeared on the public portal, was sufficiently explained when IEBC demonstrated how KIMS captured and transmitted the image of Form 34A. Accordingly, we dismiss that allegation. 3, during the ICT scrutiny, it turned out that the transmission logs produced in the affidavit of Justice Nyangaya were of no probative value. The registrar's report shows that the original Forms 34A from the contestant polling stations, which were allegedly intercepted, were exactly the same as those on the public portal, and the certified copies that were presented to this court pursuant to the provisions of Section 12 of this Supreme Court Act 2011. 4. Regarding the allegation that the integrity of the public portal was compromised, this was disproved by evidence of consistent attributes such as unique timestamps, uniform PDF conversions at the polling stations, correct polling station mapping, and consistent KIMS reporting from verification to transmission of results. 6. The RTS was configured on a virtual platform network, VPN, and the SIM cards locked to a specific polling station. The server was also configured to accept results only from authorized and properly mapped KIMS kits. In our view, the petitioners failed to produce credible evidence to the contrary. 7. A review of some of the logs presented as evidence of staging showed that they were either from logs arising from the 2017 presidential election or were outright forgeries. In our considered view, there was no evidence of a man-in-the-middle server configured to the IEBC's VPN network, and no evidence was produced to show that the chairperson of IEBC and staff were part of the arranged conspiracy to stage the transmission process. 9. Whether there was a difference between Forms 34A uploaded on the IEBC public portal and the Forms 34A received at the National Tallying Center and Forms 34A issued to the agents at the polling stations. On this issue, the first petitioner's case was that there was deliberate manipulation and tampering with Forms 34A, as demonstrated in the affidavits, to the effect that votes were being deducted from the first petitioner and being added to the first respondent. To support this petition, evidence was contained in the affidavits of Honorable Martha Karua, sworn on 21st August 2022, Celestine Anyango Opio, Arnold Ochieng Oginga, and John Mark Githongo, which was sworn also on 21st August 2022, and a further affidavit sworn on 28th August 2022. Dr. Nyangasi also swore an affidavit on 21st August 2022, and so was Martin Papa, to support that allegation of handing and subtraction of votes. On the other hand, IEBC and its chairperson urged that all Forms 34A transmitted to IEBC portal were not interfered with or manipulated. Further, that the Forms 34A signed at the polling station and issued to the agents were identical to the Forms 34A uploaded on the public portal and delivered to the National Tallying Center at the Bomas. It was contended that in any event, IEBC used the original physical Forms 34A to tally, verify, and declare the presidential election results. This court ordered scrutiny stations outlined in the affidavit